Well, good afternoon and welcome to the Wednesday Lunchtime Drive Thru today. So happy that you could make it. I'm Damon King, your short order cook here today for our lunchtime. I'm also the lead instructor for ChappelWood University, as well as a certified financial planner with ChappelWood Financial Services. Today's topic was requested by one of our clients. What should you consider when creating a will or a trust? And from a broader perspective, what should you consider just when you're building an estate plan? And so I want to talk about all of that today, or as much of it as we can. First things first, though, you need an estate plan. If you do not have an estate plan, well, let me back up. You have an estate plan. The question is it one that you built for yourself, or is it one that you are going to accept from the state that you choose to pass away in? Because every state has what are called intestacy laws. And if you pass away without a will or a trust or any other kind of legal document that dictates where your assets and stuff will go, the laws of that state will dictate those things for you. So you have an estate plan. What you need is an estate plan you have created. You deserve. Think about all the work you've put in to building up your assets, building up your wealth, the time, the pain, the anguish, the blood, sweat, and tears. Don't you believe you deserve the opportunity to decide where those assets go when you pass away? I think you do. I think you deserve it. You deserve to be able to choose the people that are going to make decisions for you, either when you are unable to make decisions for yourself due to some kind of incapacitation or when you're gone. You deserve to be able to choose that person as opposed to having a judge in a courtroom decide that for you, someone who doesn't even know you or care about you. I hear this comment a lot. Well, I'm not wealthy. I don't have anything. So I don't need an estate plan. That's totally the wrong way to think. An estate plan is not reserved for the wealthy. What is wealthy? Wealthy means a lot of different things to different people. Some people say, well, if you got $1 million, you're wealthy. And I'd say, really? I know a lot of people who have $1 million and still outlive their money or still outlive their means. They spend more than they make. To me, a wealthy person is someone who has total freedom to do whatever they want to, when they want, how they want, where they want, with whom they want, and not worry about the money. That's wealthy. Wealthy is not accumulation of a bunch of money. To me, it is financial freedom. That's what wealth is. And regardless of who you are or how much you have, you deserve the right to decide where your stuff is going to go when you're gone. So let's talk about a will, first of all. What is a will? Well, it's a legal document that spells out your wishes regarding the distribution of any assets that you have accumulated, as well as who will care for any dependents in your care. This could be minor children. This could be, maybe you are caring for aging parents. This happens a lot, right? Your parents, now the roles are reversed. You're caring for your parents, and they are now your legal dependent on your tax return. If you predecease them, who will continue their care? We have parents that have special needs children. We have one client that, a couple of clients that unfortunately, that they had a daughter just last year who was only 42 years old and she passed away. But for 22 years before that, she was virtually confined to a wheelchair because she had a neurological disease, almost like ALS, that slowly took away her physical abilities. They had to care for her. Do you think that they left it to chance? If something happened to them, who would take care of her? No, they did not. So they actually had a special trust set aside, but a will allows you to do that. And a will is the simplest estate planning tool that you can use to express your wishes. Okay, it's the simplest thing you can do. There are different types of wills. Now, the will that you are most familiar with, and you watch television shows and movies, and everybody gathers around for the reading of the will, these very dramatic moments. These are testamentary trusts, okay? It's somebody who has gone through the trouble of engaging with an attorney, typically, but the will has been witnessed. When they signed it, there was a witness there to witness I, Damon King, who I'm of sound mind and body, do bequeath, devise, blah, 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 all that legal language, the following, okay? So a testamentary trust is the most common, it's the most popular. That's a will that has been drafted, you've signed it, you've dated it, and it has been witnessed and signed by the witnesses. And it is the least likely kind of will to be challenged because there were witnesses there that said, yeah, he was of sound mind and body. She was of sound mind and body when she did this. There's another kind of will called a holographic will. Now, holographic holograph, meaning that it just pops into being, okay? This is basically a written will, all right? It can be written on a napkin. It can be written on a piece of paper, okay? But typically, a holographic will, by its nature, is not witnessed. In fact, it is not a legal requirement for a will to be witnessed. A legal will can be presented in court, and so long as the court can determine that that is indeed your signature in your handwriting and it is dated, that's really all that is required for a will to be legal. Now, of course, if there are no witnesses, if you did not engage an attorney to draft this document and it's not very well written, those kinds of wills are much more easy to challenge. So if you've got family members or heirs that feel that they have been mistreated, chances are they're going to challenge that will. And if it's a deathbed will that you wrote on your deathbed, or, we actually see this a lot, if somebody's trapped in a situation, sometimes it's a deathbed will, or there have been situations where people have been trapped in a car after a car wreck and they're going to die inside the car. There's not even time to get them out. People will sign a will while they're dying trapped inside of a car. I've actually heard of this happening. Now, a holographic will is not legal in all states. It is legal in the state of Oklahoma. It's not legal in all states. I don't recommend you go this route. You want to go with a testamentary trust, a testamentary will, if nothing, and nothing else. Then there's a pour-over will. Now, a pour-over will is a very special kind of will that is found inside of a trust. We're going to talk about trusts here in a second. And it's usually in a trust, and it helps to capture any other assets that between the time you created your trust and the time you pass away, any assets that you accumulated, like a car or a truck or a house or a farm or whatever, and you didn't get it retitled in the name of the trust, the pour-over will kind of acts as a catch-all for all of those assets and then moves it into the trust. So those assets are in the will, and then the will pours over into the trust once it's been probated, that sort of thing. So as I said, wills do not require a witness, but it's a good idea to have a witness so that you can avoid any legal challenges to your will. What is a trust? A trust is a totally different animal. It is a fiduciary relationship where one party, the trustor, who has the assets, agrees to give those assets to another party, the trustee, and hold those assets and typically manage those assets for the benefit and enjoyment of someone else, a beneficiary. Now, the way that I describe a trust is, think of it like a big travel, those big steamer trunks that people used to take on transatlantic voyages when we had steamships, things like that, or a big treasure chest. It's like that. But it's a big chest that you can put all of your assets in, your valuables. Those assets can be professionally managed by an investment advisor or a trust company, something like that. These assets are intended to benefit you and then your heirs later on when you're gone. And it is protected for the most part from the outside world. All right. So a trust is a great way to package up and wrap up a lot of your assets to protect them from creditors, protect them from prying eyes, to protect your privacy. And we're going to talk in more detail about some of the pros and cons of a will and a trust. Here's how a revocable living trust works. All right. And this is the most common type of trust. If you're thinking of setting up a trust, chances are it's to set up a revocable living trust. Now, there are other kinds of trusts. You've heard of revocable and irrevocable or irrevocable. A revocable trust, by its name, means you can revoke it. You can change it. You can make changes to it at any time. An irrevocable or irrevocable trust means that once it's done, there is no changing it. What we're talking about today is the revocable living trust. A licensed attorney is required to help you set this up. All right. You're going to title your assets like your house, your cars, your bank accounts, maybe even investment accounts in the name of the trust. From a legal standpoint, You no longer own the asset. Your trust owns the asset. But who controls the trust? You do. You are the grantor of the trust. You retain control over the trust so long as you are living. You control who gets what. You control which assets are in the trust, and you can revoke any of those privileges at any time. So you control the assets while you're living. You get to enjoy them. And while you are still living, there is no difference between you and the trust from a tax standpoint. The IRS does not view any difference. So, for example, if you title your bank account, your savings account, or your money market account in the name of the trust. So, my wife and I, we have a trust, the Damon M. and Kathleen L. King Revocable Living Trust. That is the actual legal name of our trust. Our bank accounts are titled in the name of our trust. Our checkbook even has checks that have the title of that trust on it. But guess what? We can write checks on it anytime we want. We can pay bills from it anytime we want. And every year, when we get the statement of interest paid for our taxes, there's not a special tax return we have to file for the trust. That all flows through to our personal tax return, and we pay the taxes on that. So that's kind of a nice thing, is that you don't have to worry about that. Now, later on, when you pass away, or whoever is the second of us to die, and the trust comes into actual being, well, then our kids at that point in time will have to go and get a tax ID number for the trust. The trust will pay its own taxes, things like that. But we don't care about that because you're still living. All right. And as I always say, if you ever have any questions at any time today on anything that we're talking about, please put those questions in the Q&A box, or you can share them in the chat. I'll see them because there's a good chance we're going to have quite a few questions today about this. What about the pros and cons of a will? Every strategy, every financial strategy has advantages, and then there are disadvantages. I tell you this all the time. I don't ever want you to be the kind of person who says this is good and this is bad. That kind of absolutism does not work in the world of finance. Every strategy was created for a purpose, which means that there are some purposes it is not appropriate for, right? So there are certain things that a will is really good at. There are certain things it is not good at. And the same is true of a trust. For example, a will, fairly inexpensive. It's the simplest, least expensive thing that you can do if you want to set up an estate plan, all right? It doesn't even require an attorney, as we've already discussed. However, I strongly, strongly encourage you to engage a licensed attorney to draft any kind of legal document, okay? You can go on LegalZoom.com and you can pay 25 bucks and you can get a will done, all right? And you can even have it witnessed and all that stuff, and it's a perfectly legal will. It's also going to be a lot easier to contest it because there may be something you missed, all right? All of the online stuff is great. It's never going to beat a professional who has experience and knows what they're doing and can ask you questions face to face, and you can ask them questions. I don't care. All the algorithms and computer stuff, it's great. It's never going to beat a one-on-one person. Never, ever. And you're never going to convince me otherwise. A will goes through probate. Oh, looks like we got a question here. All right, so we do have a question from Eddie. Eddie asks, if you have a revocable trust, can you just leave your bank and investment accounts in your personal name and then POD them to the trust at the time of death? The answer is yes, you can do that. When you set up a trust, there is no requirement that you retitle your assets in the name of a trust, all right? A lot of people do this. They set up the trust, but they keep their bank account, they keep their house, they keep their cars in their name, and then they can make the trust, the trust is the beneficiary of those assets. So you can absolutely tell your estate plan, okay, I want the house to go into my trust, and my trust will then sell the house for the benefit of my heirs. Your bank account, your bank is going to require you to name a beneficiary. So you can name your trust as the beneficiary. You can name your trust the beneficiary of your life insurance policy, but keep the life insurance policy in your name, all right? A trust can also own the life insurance policy. Same with investment accounts. You can either take your After tax, now a trust cannot own an IRA. If you have an IRA or a 401k, something like that, that is a tax-deferred personal account, your trust cannot own that. It can be the beneficiary, but it cannot own it. But if you have an after-tax brokerage account that you get a 1099 for, you can absolutely retitle that account in the name of your trust, or you can simply name your trust as the beneficiary of those kinds of things. So that's a great question, Eddie. Now, I will tell you that, actually, I'll make this comment or ask this question. If you went through the time and expense of setting up the trust, but you didn't retitle any assets in the name of the trust, what is the true intention of the trust? I can tell you that while you can certainly leave certain assets to the trust, there is still the potential that there could be some contesting, that sort of thing. If you already have the assets in the trust, it's a lot harder for anybody to contest those assets after you die. All right. Even your family. All right. But anything that is outside of the trust can still be subject to contest, can be subject to legal wrangling before it makes its way into the trust. So just understand that. Okay. But it's a great question. All right. So what are some of the pros and cons of a will? We've already talked about how inexpensive they can be. You don't need an attorney. But one of the cons of a will is that it does go through what's called a probate process. Now, the word probate can strike fear into the hearts of people. And if you've ever been through a probate process, many of you on our call today have been through that process. You know that it can be time consuming. It can be expensive. And if you have a job and a life and other things you're doing and you don't know what you're doing, it can be an extremely laborious, mind-numbing, nerve-wracking process. Okay. It doesn't have to be that way, but it often is. So probate by its own nature is not necessarily a bad thing, but it's because of what you have to go through. You have to go down to the courthouse and you have to file the probate, and a judge has to certify that this is indeed the last will and testament of John Doe, and now you are the personal representative. I empower you to now go forth and make this happen. When that happens, all probated wills become public record. You can go online to the county records and research wills currently going through probate. All right. This makes your private information public. And if you would much rather keep your private information private, then using a will might not be what you want to do. But if simplicity and low cost are the most important things to you, a will might be your best choice. Okay. So when you're thinking about how do I determine, to me, it's not even a question of, oh, I either don't own a lot of stuff or I do own a lot of stuff. That can play a role in whether you go with a will or a trust. But to me, a trust is just as good for somebody who doesn't own a lot of stuff as it is for someone who does. When I set my trust up, I set my trust up about 15 years ago when I was a lot younger and I had a lot less stuff and money. Okay. But I knew, my wife and I knew that's the route we were going to go. So we went ahead and did it, even though we didn't have much at that time. Heck, we didn't even have our 2 kids at that time. So a lot has changed and we have updated our trust in that time frame. Let's talk about the pros and cons of a trust. A trust is typically going to be more expensive than a will. All right. Where a will from an attorney might cost you $300, maybe $500 on the outside. A trust is going to cost you $3,000 to $5,000. Okay. They're more complex. There's more to it, which means there's more work for the attorney to do. All right. So it's going to be more expensive. It requires, whereas with a will, an attorney is an option. With a trust, you have to have an attorney. Okay. I tell our clients all the time, I'm not an attorney. Victoria's not an attorney. None of us here are attorneys. We cannot draft legal documents. We can certainly help you construct what should be in your trust. I can teach you what should be in your estate plan. You're still going to require a licensed attorney to put it together. It's also going to require, if you're going to fund the trust, it's going to require retitling of your assets. And that can take some time. That can be difficult. Now, one thing I will say about this is, if you're going to put a trust together, and you want to get your house and your cars and all these assets retitled in the name of your trust, part of what you hire that attorney to do should be, and you need to negotiate this, and you should ask this question. In addition to drafting the trust documents for me, are you also going to help me retitle those assets? Okay. They should do it for you. They should be able to file a quitclaim deed with the county courthouse or the county clerk to retitle your house, the deed, in the name of your trust. They should be able to help you do that. They should be able to help you put the paperwork together to go down to the tag agency to file a deed change or a title change on your car. Okay. If all they do is put the trust together and then they don't ever help you retitle anything, you know what's going to happen? You're going to forget about it. Or you're going to get overwhelmed and you're going to be like, well, I don't want to go down to the courthouse. I don't know how to fill out a quitclaim deed. I don't know what the hell I'm doing. And you're never going to get it done. And you have somewhat negated some of the power, some of the reason why you set the trust up in the first place. Eddie has another county here. My dad has a will, but we have POD'd all his bank investment accounts and his house to my brother and me. Can we bypass probate with the POD? And POD is pay on death. Sometimes it's TOD, transfer on death. Eddie, it's a great question. Now, on the bank and investment accounts, any account, any asset that has a named beneficiary. So this would be a life insurance policy. This would be an annuity policy. This would be a retirement account, an investment account, a bank account, anything like that you can actually name a named beneficiary. That beneficiary designation will supersede anything you have in your estate plan, anything in your will or your trust. It passes by process of law, and then as a result, it can bypass the probate process. All right, potentially. All right. There is still a chance, though, that those assets could be added to the estate and to the will. So my answer is maybe on that. Now with the house, again, I'm not sure that would meet the legal requirement of bypassing probate. And this is where I'm going to tell you, I'm not an attorney. So I would strongly encourage you to get an answer from a qualified licensed estate planning attorney to answer that question. But I'll tell you what, I'm going to research it. I do that all the time. So it's a great question, and I'll research that. All right. So great. Thank you for asking that question. All right. A trust avoids probate, and let's see. Oh, we have another question here from Wendy. See, I prefer the questions over this. Would you recommend that an adult child, we only have one child, and I know who you're talking about, Wendy. Would you recommend that an adult child or an outside party be the executor of a trust? Pros and cons. Great question. All right. So part of your estate planning process is going to be to choose a personal representative. Okay. Someone that will represent you when you're gone. Now, if you're the first spouse to pass away and you're married, so Wendy, in your case, okay, your husband is going, if you predecease him, well, then he's going to take over everything, right? But when you're both gone, who would you name? Most people will choose a family member, okay? A son, a daughter, some other kind of family member. Is that the best thing to do, though? Particularly with a trust, all right? With a will, it's not as big a deal. But with a trust, often what I like to see is someone to name a third-party trustee. That's what I've done with my trust. I have named a third-party trustee, a trust company, to be my personal representative when I am gone, or when my wife is gone too. When both of us are gone, a third-party trustee will represent our interests as it relates to the trust. Why did we go with that? Because number one, we cannot guarantee that our children, one of our sons or both of our sons, would want the job in the first place. You can choose anybody you want. You can name anybody you want. They don't have to accept the job. They can recuse themselves. So then what happens? A third-party trustee is less likely to do that. It's a trust company. That's their whole purpose. But the other reason we chose a third trustee, and probably the more important one, is that we did not want to put any of our family members in the position of being the person that everybody else comes to for money. Okay? Trust me, when you pass away and you've got a couple $1 million left or whatever, and you've named your son or your daughter, in your case, your daughter, Wendy, if there are other people who have some claim to that estate, or even creditors who have some claim to your estate, do you really want everyone going to your son or your daughter asking for money? I've seen it happen many times where siblings are coming to their oldest sibling because, even though we're long past the days of patrilineal, the oldest male child receives all of the stuff and all that. People still tend to choose their oldest child. Do you really want your kids going to the other kid asking them for money, putting pressure on them? Come on, man. Mom would want me to have my $250,000 now. Really? A third-party trustee doesn't have that kind of problem. A third-party trustee is going to say, oh, thank you so much for your request, Mr. King. It says here that you're entitled to X amount of income every year. Thank you so much. Here's your payment. Bye-bye. And they're not going to have any pressure whatsoever. They are following the law. So one of the pros of having that is, of course, a third-party trustee, is that there's no pressure on your family. Now, what's one of the cons? Well, that trust company could go out of business, right? Or maybe you don't like them anymore, but you forget. So, but still, I'm a big believer, if you're going to use a trust, for me personally, and this is what I would recommend you do, Wendy, and any of my clients, I would recommend choosing a third-party trustee. You're going to get professional money management, because that's what they do. They manage assets, and you're going to get professional advice. Your family is going to get ongoing professional advice. We did have another comment here. Preach on, bro. Ralph says, preach on, brother. There you go, Ralph. See, Ralph and I, we're on the same page here. I just don't think it's a good idea putting family members in the position of having to dictate where money goes and that sort of thing. It's different if you're going to say in a will, Johnny, you get this, and Tammy, you get this, and then everybody goes their separate ways. You don't want your family members, at least from my perspective, to be in the position of being the banker and doling out money. That's a recipe for disaster. I hope that helps, Wendy. We can talk more about that when you guys come in for your next review. Okay, so we'll put that on the agenda. All right. The trust avoids probate. It keeps your private information private. There's an easier transition of assets to your heirs. And you actually, with a trust, can have control of your assets from beyond the grave. So if you have a will and you just leave, son number one and son number two, $50,000 a piece, they're just going to have $50,000, all right? However, okay, we got another great question. I'm going to answer that question. I'll come back to that because it's a good question, but I want to finish this thought real quick. Let's say that you have a child that, for whatever reason, has just never really got their stuff together, okay? There's failure to launch, and you've done everything you can to try to teach them, but they just keep making really bad money decisions and maybe bad life decisions, or you don't agree with their lifestyle that they've chosen, whatever. And you're really concerned that if you just drop $500,000 on them when you go, that money that should last them a long time is just going to be blown in one weekend in Vegas. A trust allows you to control the flow of assets over time. So instead of leaving them the principal, instead, maybe you can dole out income over time. The $500,000 will be invested and managed professionally, and then you'll receive the income from that over time. Until you get to an age somewhere when you're 137 years old, and I believe you're mature enough to handle this, then you can have whatever remains of the principal. But that's what I mean, control of the assets from beyond the grave. The trust, typically, there's no probate process, so it just kind of passes to your heirs. They just get what they get, it takes less time typically, okay? And more importantly, they will not print in the newspaper that John Q or Jane Q died and her will is now going through probate. That doesn't happen with your trust unless you have a pour over will inside your trust. Those assets will go through probate. So your goal is, if you're going to set up a trust, I guarantee you the attorney that does it for you will carve out a little pour over will inside there. It's like a little country that lives inside, that's surrounded on all sides by the bigger country. And then it will pour those assets into the trust later. Your goal is to try to make sure that everything you want in the trust gets in the trust before you die, all right? So if privacy and control of your assets are most important to you and they are worth paying a little more, then a trust might be the best choice for you, okay? Now, I want to come back to this question that was asked, because it's a great question. And this is from an anonymous attendee today. How does one pick a third-party trustee? What should one look for? So one of the things that typically third-party trustees are going to be like your bank. So you could actually choose your bank or your financial institution to be your third-party trustee. What you want to do is check with your financial institution, ask them, do you all have trust management services? Do you all manage trusts? I know Wells Fargo does. So if you're a Wells Fargo bank, many of the large banks will have trust services. Here at ChappelWood Financial, the investment strategist that we use actually has trust services. We can well, it's not going to be us, but our investment partner, our custodian, can actually act as a third-party trustee. So if you have a financial advisor, ask your financial advisor if they have the ability to serve as a third-party trustee. And you want to know, what are the costs? Okay. What kind of professional management would my family have access to? What kind of education would you provide to my family? When I'm gone, how would you help with an orderly distribution of assets to my family? These are some of the questions that you would want to ask and get an answer to. There are also companies, trust companies. Okay, there are two that I can think of. There's Heritage Trust here in the Oklahoma City area, very big trust company, been around for a long time. I think there's the Trust Company of Oklahoma. I think that's the name of it. That's another trust company. That's really all they do, is manage assets for trusts. So those are just a few things, but check with your bank, check with your financial advisor, and you want to ask them, what fees are involved? How will you help my family in the transition? What kind of guidance will you help my family manage their assets? Would you take, if I've been your client for all these years, would you then work with my family, my kids as your clients? And you want to hear the answer, yes. Okay. So I hope that helps. Those are some of the things that I would ask and that you should ask too when you're looking at a third-party trustee. Some other things you want to look for, you want to make sure that they have a fiduciary responsibility to you. All right. Just like as an investment advisor and an investment advisory firm, we have a fiduciary responsibility to our clients while they're living. Well, that fiduciary responsibility would pass on to your family if we're managing the assets that are inside of a trust. So you want to make sure that that is also part and parcel of what you're going to get with a third-party trustee. All right. Let us continue on here. So considerations for a will or trust, and these are in no particular order. These are just as I thought of them. Okay, and I am going to try to be done by 1 o'clock. All right, so I'm going to try to give you actually a little bit more than 30 minutes today. So do you prefer to keep costs low with your estate plan? If so, you might want to look at a will. Do you have a lot of assets to pass that you know are going to require some professional management? If that's the case, a trust is probably the way that you want to go. Do you value your privacy? If so, a trust is the way that you want to go. Do you prefer simplicity? In that case, you're looking at a will. Right? Do you want to exert control, have even more control of your assets from even beyond the grave after death? A trust is going to give you more freedom, more ability to do that because you have set forth your instructions well before you passed away. Do you have a child or other dependent that will require care after you're gone? Now, you can achieve this with both a will and a trust, but with a will, all that you're going to do is set aside money for somebody, for a dependent, and once they receive it, you're counting on them to do what they need to do with it. If you're going to set up a trust, for example, I'll go back to those clients that had the daughter that passed away tragically last year after a long illness. While she was still living, part of their trust, if they had both died and predeceased her, then $1 million of the roughly 3 million that we manage for them would have been carved off and set aside in another special trust called a special needs trust or a supplemental needs trust. And it would be $1 million that would have gone to Sharon, well, at least for her care and benefit. We would have managed those assets, but then we would have made sure that all of her medical bills get paid. We would make sure that she's got enough money to do all the things that she wants to do for her adult daycare, that sort of thing. Now, she predeceased them, and it ended up that we didn't need that. So the supplemental needs trust evaporated, it went away. But those are some of the things that you want to think about. We did get another question here. Okay, so here's another question that I commonly get, and this is again from an anonymous attendee. Do you recommend a net worth dollar threshold of when you should use a trust versus a will? And this is kind of a hard question for me to answer because in most cases, I don't really think about the need for a will or a trust based upon your net worth. Now, does it make more sense to have a will when you've got less than $500,000? Probably, probably, because you've got less stuff. And quite frankly, there's probably not a need to spend more money and go through the time and the expense of a trust when you don't have as much to pass on. But if in addition to a $500,000, you've got $500,000 in just investments or liquid assets, then you got a house and you got cars and maybe you own a business, it is possible to have less than $500,000 in liquid assets, but yet your net worth is still north of that. It could make sense. If you've got a net worth of, $500,000 or more, to me, that's kind of that point at which a trust begins to make sense for you, because chances are you've got a lot of stuff. And again, it's not just your investments and your cash, it's your other stuff, right? That's a lot of stuff. And there's a house to be sold and there's all this stuff. Certainly when you have a net worth north of $1 million, that's when I really start to recommend a trust, okay? Because you've got a lot more moving parts. You're going to probably require some professional management for your family. So at $500,000, I'd say you could go either way. At $1 million net worth, I'd say I would probably consider a trust. It's going to cost you a few $1,000s. That's not much in the grand scheme of things to know that your private information is going to stay private. All of this is going to be wrapped up inside your trust, and your family's not going to really have to worry about it, okay? The more stuff you have, the more chance that your family doesn't want to have to mess with it, or they could screw it up or whatever, okay? It's a great question. So hopefully that gives you a good starting point. If you've got a $500,000 net worth, I'd think about it, look into it. If you've got $1 million plus net worth, I would absolutely look at a trust. All right, let us continue on. Some other estate planning considerations. You definitely want to include as part of your overall estate planning package, medical and financial powers of attorney. So if you become incapacitated, I don't mean that you're brain dead, but I mean that you're whatever, you're in a coma, or you've gone through a major surgery and you can't answer anybody's questions, you're medically sedated, whatever. Or you're not of sound mind to make decisions that are in your best interest. You want to have what are called powers of attorney and name someone else. And if you're married, usually it's going to be your spouse, or maybe it's going to be a child or something like that, who will make medical and financial decisions that are in your best interests when you are unable to for yourself. Related to that, but totally different, is what's called an advance directive, or sometimes you hear this called a living will. If you are now in a persistently vegetative state, you're not coming back, or you're hooked up to life support, and the only things keeping you alive are machines, how long do you want to stay on those life support devices? How long do you want the feeding tube in? That sort of thing. You do not want to put your family in the position of having to decide to pull mom or dad off the plug. Don't make them have to make that decision. What do you think they're going to do? They're going to let you linger on, more than likely, because they don't want you to die. Take the decision out of their hands. Even if they know that the humane thing to do is to pull your plug, how hard do you think that's going to be for them? I don't want to have to kill my own mom, or at least give authorization. Yeah, let mom die. Thankfully, I don't have to make that choice. My mom and dad have already put together living wills. You should do the same. Because what you don't want to have happen, do you remember the Terry Schiavo case? The young woman that sat on life support for years because her parents wanted to keep her on life support. Her husband wanted to take her off, and they fought. You don't want members of your family fighting over keep mom on the ventilator or not, because that's unnecessary. It creates divisions in your family. So just have it done now. You want to make sure that you update and name beneficiaries on all your life insurance policies, your retirement accounts, things like that. This is especially true if you get remarried, whether you got divorced or your spouse died and then you get remarried. You don't want to have a dead person named as the beneficiary. That's not a good thing. You especially don't want to get divorced, get remarried, but you accidentally left your ex-spouse as the beneficiary on all your assets, when you really intended it to go to your current spouse. Because when you die and they have the reading of the will, and your current spouse thinks he or she is going to get all this money, but the beneficiary is your ex-spouse, who do you think is going to get the money? The beneficiary. That's what the custodian is going to do. So make sure that you update your beneficiary designations or review them periodically. You want to choose your personal representative. Who's going to represent you? Your executor. Who's going to do this for you? And talk to them beforehand. Make sure that they want the job first. It's a lot easier to talk to them about it while you're living than when you're dead. All right. And then finally, share your plans with your family. Now, I know this one is a little tough to swallow for some of you, because you're thinking, I don't want my family to know that they're going to get all this money. I want them to go out and just live their life, and they'll find out about it when they find out about it. But I will tell you this, you don't have to share every detail, but families who talk about money and share what's going on with their money have a far less likely chance of having challenges, having the will or the trust challenged when you're gone. All right. Money tears families apart. I see it all the time. Even the best families can be ripped apart because of fighting over money. So try to remove the fight to the best of your ability. All right. Are there any other questions? It's just after 1 o'clock. I know this was a little unorthodox today. Generally, we're done by 12:30, but are there any other questions? We've had some really great questions today. So I want to make sure that that one's answered. We answered this question that Wendy asked. That's good. We answered a question, that one right there. Are there any other questions that anybody has today related to estate planning, the difference between a will and a trust, just anything that you'd like to ask? Now is the time. While you're thinking about your question, I like to multitask here. So while you're thinking about that, I want to let you know that we're taking a break on Rock Your Retirement for this month, but we're coming back with full force for our next class starting in 2021. So if you or someone you know, you're ready to know what you don't know, you're ready to go beyond just these 30-minute weekly chats and really dive into what's going on with your retirement plan. What do you need to know about income planning, and so you don't run out of money, and how to structure your portfolio, how to lower your tax bill. We talk about estate planning. We talk about how do you cover health expenses and what are the different options for Medicare, things like that. How do you choose Social Security? All of that we cover in our Rock Your Retirement course. The next one's coming up January 21st and 28th. Those are Thursday evenings from 6:30 to 8:30. And so I would love to see you there. We do have, let's see, Wendy asks, what are the typical costs to make changes to a trust? For instance, adding or removing a vehicle to or from your trust. So It really depends, Wendy. Sometimes attorneys, especially if you've got a good relationship with them, and often we might see this with sort of a standalone attorney, a lone wolf, less likely in a larger firm. Sometimes they'll just do it for free if it's a small change. Now, if you paid, let's say, $3,000 to $5,000 for the overall trust, but all you need is some minor changes, well, then they're probably just going to charge you whatever their hourly fee is. Okay, as it says, they say, okay, this is going to take me an hour to do this, so I charge $300 an hour, whatever their fee is. It's certainly not going to cost nearly as much as the original trust, unless you just have a total overhaul. But for something as simple as retitling a vehicle or something like that into your trust, I mean, I would expect a few $100s maybe, something like that. I can't imagine that they would charge you much more than that for something that simple. And if they are, I might go around and get quotes from other attorneys. Just because one attorney drafted your trust doesn't mean another attorney can't also take a look at it and make changes. I mean, the language is pretty standard from one attorney to the next. Just because one investment advisor sets up your portfolio doesn't mean another one can't look at it and make recommendations. So great question, though. All right, it doesn't look like we have any other questions for today, so I want to say thank you again for joining us here today on the Wednesday Lunchtime Drive-Thru. I hope you enjoyed this. Thank you again to Wendy for suggesting this topic. We're going to have another great topic next week that Eddie asked, and so we'll check your email inbox next week, and you'll see what that's going to be all about. Until then, have a great rest of your week. Have a safe and blessed weekend, and we'll talk to you soon. Bye-bye.